Hi everyone, Attorney Adam Schmalzi here in my office located at 47 Harvard Street in Worcester, Massachusetts. If you received a notice to appear for a Massachusetts Clerk Magistrates Hearing, you might have some questions. The purpose of this video is to explain what a magistrate's hearing is and to help you understand the process, to give you some tips on what you can do to prepare for your hearing, and to explain what happens after the hearing is over. Let's get right into it. A clerk magistrate's hearing is also known as a show cause hearing. And a show cause hearing is scheduled when a police officer or another person fills out an application with the court asking them to issue a criminal complaint against you. When you receive a notice to appear at a clerk magistrate's hearing, you're being given an opportunity to demonstrate to a district court clerk magistrate that there is no probable cause to believe you committed a crime. If you're successful in your demonstration, you will not be arraigned on that issue after the hearing, and the charges on the complaint will never appear on your criminal record. So, who is a clerk magistrate? A clerk magistrate is a person who has been nominated and appointed by the governor and confirmed by a majority vote of the governor's council members. While they're not in fact judges themselves, they are appointed through the same judicial nomination process as judges. It isn't only their job to conduct show cause hearings on criminal complaints, but they do have the authority to. And they determine the weight of the evidence and decide whether or not to issue the complaint. Here is an example of what a notice of a magistrate's hearing might look like. At the top, you will see the docket number for the case. This is the reference number for your particular matter. If you have a question for the court or you'd like to reference the case in some way, this is the number you'd need to provide for the case to be located. Just underneath, you'll see the name of the parties to the case. In this case, you see Jane Smith versus John Doe. This likely means that Jane Smith took out a complaint privately against John Doe. Jane would be the plaintiff and John would be the defendant. Now, at this point, John has not been arrested. He is merely being accused. If the magistrate decides that there is probable cause to show that John may have committed this crime, the plaintiff will become the Commonwealth of Massachusetts and John will need to be arraigned. Under the names of the parties is John's address, and to the right is the name of the court and the address where you need to appear for your hearing. On the left, where it says Police Department/applicant, we again see Jane's name confirming that she did in fact take out this complaint on her own. If the police took out the complaint, their name would appear in this box and the department would be listed as the plaintiff. In the box on the right, there is an incident report number. If there's a report number in this box, it would be crucial to your defense to obtain a copy of it. That way you can understand the basis of the allegations and you can see what the plaintiff might have said to the police prior to the hearing. Many times the information in the incident report will be different from the testimony in the hearing. To the right of the incident report is the date and time of the hearing. It should go without saying that this might be the most important piece of information on this notice, because if you aren't there, the complaint will likely issue without your objection. In the box below, the offenses are listed by count. In this case, there is one count. The code is the reference to the Massachusetts statute, Chapter 265, Section 13MB, and to the right is the name of that charge. In this example, it is an assault and battery of a family household member. To the right is the date that offense allegedly occurred. The remainder of the document contains other information related to the hearing itself, and at the bottom, we would have the date the complaint was issued and the name of the clerk magistrate who issued it. Now again, the purpose of this hearing is for a determination to be made as to whether or not probable cause exists for the complaint to actually issue. In my previous example, John Doe is being charged with assault and battery of a family household member. One of the four elements of that particular crime is that the defendant and the complaining witness, Jane Smith, were in fact family or household members at the time the offense was committed. If Jane fails to demonstrate that particular element, the clerk may not issue that complaint. I think this is a great example to use for this type of video because even though John hasn't been arraigned and this hearing is not in front of a judge, it's still a recorded hearing. That means that John may have a Fifth Amendment privilege not to testify. What do I mean by this? Well, let's assume that there was an incident where John did in fact assault Jane, but they weren't household members. If John's testimony knocks out that element of being a family or household member, he could still be charged with assault and battery against Jane under another statute. John might at that point decide to refrain from testifying and to have his lawyer argue on his behalf. A defendant can present their own evidence at that hearing to support their argument. Let's assume John had a witness to the event who could shed some light on their observations. John or his lawyer may call that witness to the hearing to testify. If he has a photo or some recording that can be properly authenticated, that too can be used as a tool for the defense. When the parties are done with their arguments, the clerk magistrate will make a final decision. If the complaint issues, you'll be given a date to appear in the district court for your arraignment. If the clerk magistrate finds no probable cause to issue the complaint, you will not be arraigned. One can represent themselves in a magistrate's hearing if they choose to, but an experienced lawyer can help guide you through the process and help you put together an effective strategy to defend against that allegation. If you have any questions, email me directly at litigatema@gmail.com or call my office at 774-314-9124. Thank you.